Today we will discuss the provisions of Order 1 regarding what? Parties to the suits and representative suit. In the previous class, we discussed who are to be made as plaintiffs. All persons who are entitled for a common relief, they are to be made as plaintiff in the suit. In other words, if those plaintiffs will file separate suit, then the common question of law or fact will arise. Similarly, all persons against whom same relief exists, same relief is claimed, then those persons be made as defendants. Now, there is provision in Order 1 that when a court finds that some plaintiff has been erroneously made as plaintiffs, and if there will be a common trial that will cause embarrassment or prejudice to the parties, then the court may direct the plaintiff to file separate suits. Similarly, the court has also power to direct for separate trials when joinder of defendants may embarrass or delay trial. When some defendants have been joined and the joinder of those defendants will cause embarrassment or will cause delay in trial, so in such case, the court may direct that there will be separate trial. Defendant need not be interested in all the relief claimed. This Order 1 Rule 5 provides that it shall not be necessary that every defendant shall be interested as to all the reliefs claimed in any suit against him. Similarly, Order 1 Rule 6 provides joinder of public parties liable on same contract. The plaintiff may at his option join as parties to the same suit all or any of the persons severally or jointly and severally liable on any contract, including parties to bills of exchange, hundis and promissory note. You are aware what is promissory note? Promissory note is an instrument in writing containing an unconditional undertaking to pay certain sum money only to the bearer or as per the order of the bearer. The promissory note changes from hand, it is by endorsement to other person. So all persons who are liable under a promissory note. Similarly, bill of exchange, under a bill of exchange, all persons who are liable, they may be included as defendants. So here, this Order 1 Rule 4 provides court may give judgment for or against one or more of joint parties. Judgment may be given without any amending the plaint, for such one or more of the plaintiffs as may be found to be entitled to relief, for such relief as he or they may be entitled. So it is not necessary. Suppose the court finds that one of the plaintiff is entitled for certain relief, even no amendment of the plaint is there. This Order 1 Rule 4 that empowers the court to give past judgment when one or more of such plaintiffs is entitled to get some relief, even without amending the plaint, the court can give such relief. Similarly, without amending the plaint, the court can also pass a decree against one or more of the defendants which is found to be liable according to their respective liabilities. That is in Order 1 Rule 4. Then Order 1 Rule 7, where plaintiff is in doubt from whom redress is to be sought. Suppose plaintiff is in doubt as to which of the defendant is liable for a particular claim. In such case, where the plaintiff is in doubt as to the person from whom he is entitled to obtain redress, he may join two or more defendants in order that the question as to which of the defendant is liable and to what extent may be determined as between all parties. So he may join the defendants and the court will decide, leaving the matter to be decided by the court as to which of the defendant is liable. If the plaintiff is in doubt. Suppose, that is for an example, suppose X had borrowed money from Y. X is dead. His X legal representatives are liable to pay the money, so from the property inherited by them. So in such case, suppose this X is in doubt, which of the legal representative is liable, legal heir is liable. So here he may include any, all or any of the representative, and in such case the court will decide as to which of the defendant is liable to discharge that debt. Now, the very most important provision in Order 1, that is representative suit. What is representative suit? The nomenclature itself shows that a suit where the plaintiff represents others. So representative suit and a person when a suit is filed representing another, that is different. Suppose a suit is filed on behalf of a minor representing the minor, that is not a representative suit. Representative suit is filed as per the provisions of Order 1, Rule 8 of the CPC. What it provides? Where there are numerous persons having the same interest in one suit. Where there are numerous persons. What is numerous? Numerous means you cannot say, a person cannot say what is the exact number of those persons. Where there are numerous persons having the same interest in one suit. Those persons, how many persons one cannot count and one cannot say in exact number. Those persons have same interest in the suit. One or more of such persons means those persons who have interest in the suit, who have locus standi in this to file the case, who have filed the suit, who have an interest in the suit. One or more persons who have interest in suit, with the permission of the court, sue or be sued. Sue means one or more person may file the suit as plaintiff, or may be sued, or their suit may be filed against them as defendants on behalf of or for the benefit of all persons so interested. You should understand, the representative suit is filed on behalf of numerous persons, for benefit of all persons so interested. So a suit may be filed, in the representative suit may be filed by the plaintiffs, or a representative suit may be filed against some persons who represent the defendants. Similarly, that is called representative suit. For an example, X filed a suit in respect of a particular piece of land which has been shown as public road in the settlement record. X says it is my private land. So here it is a public road, it has been mentioned in the settlement record as a public road. The persons of the nearby village or his own village, they are claiming that they have a public right to use that land as road. Suppose X filed a suit. What for? To declare that land is private land. The public or the villagers have no right to use that land as road. So in such case, you will file the suit against the persons who are claiming that private land as road. So how many persons are claiming? The villagers, there are many persons in that particular village, from a child, a woman, a old man, there may be 1,000 persons in that village. So in such case, so he is required to file the suit against all the persons. But it is not practically possible, because it may not be practically possible to implicate all the persons. If you will file separate suit against all the persons, there will be thousands of cases. So the court will also decide the common question of fact and law in all the suits. So in order to save time of the court, and in order to avoid inconvenience both to the plaintiff and also to the defendants, provisions have been made in Order 1, Rule 8 of the Civil Procedure Code. when a suit is to be filed by numerous persons having the same interest, or a suit is to be filed against numerous persons against whom a same relief is claimed. In such case, any one of such person or more than two persons, either one of such person or two to three of such persons may, with the permission of the court. So with the leave of the court means on taking permission from the court may institute that suit. That suit is called representative suit. Here, what is the difference between representative suit and a suit which is in which a person is representing another? For an example, a suit is filed on behalf of the minor by the guardian. So guardian has no interest in the suit, but only he represents the minor in that suit. Only minor has the interest. But here in this representative suit, the person has interest with others, numerous persons. One or more persons, such person means amongst those numerous persons. Among those numerous persons who have interest in the suit or who are liable under the suit, such a suit may be filed. So difference, you should understand the difference between representative suit and a suit filed by somebody representing another. In case of minor, innocent person, as a person as a files a suit as a trustee, so here he represents the other person. But in representative suit, a suit is to be filed by numerous persons or against numerous persons having the same interest or same liability. In such case, any one or more of such among such numerous persons may file a suit, or such a suit may be filed against one or more of such numerous persons as defendants. But for filing such suit, the permission of the court is sine qua non. That is absolutely necessary. Before filing for institution of suit, such a permission is required under the law. Then the subclause B says, court may direct that one or more of such person may sue or be sued or may defend such suit on behalf of or for the benefit of all persons so interested. This Rule 8b provides that even if a person if some persons have not filed a suit as representative suit on behalf of numerous persons, but during hearing of the court, during hearing in the court, it comes to the notice of the court that numerous persons have interest. Then in such case, the court may direct that some persons be made as either as plaintiff or as defendants on behalf of numerous persons. For an example, X has filed a suit claiming a particular piece of land which has been recorded as public road in the settlement records, claiming that it is his private land. He has filed that suit against the government of Odisha, but has not included the villagers, those persons who have this public right over that land. So in such case, the court may direct that the villagers or the persons of the village who are entitled to use that road as per the settlement records, they be made as defendants and they be pleaded as defendants as numerous persons, or 2 or 3 persons of that village may be added as defendant representing other numerous villagers. So that is, the court may, plaintiffs may file either a representative suit on behalf of numerous persons, or a person may file a suit against the defendants as defendants representing other persons in a representative character. Similarly, in appropriate case, the court finds such a suit has not been filed, but it appears to the court that the other numerous persons have interest. The court may also direct that some persons, such persons may be pleaded as plaintiff or the defendants as per the provisions of order 1, rule 8b, that they be implemented either as plaintiff or as defendants as representative of other numerous persons. Then first, the requirement is that permission is required. If plaintiffs file, a plaintiff files as a plaintiff, a suit is filed in the representative suit as a plaintiff or as against defendants with permission of the court. Then if court directs, okay, no state of permission, court feels that court passes order, some person be implemented as plaintiffs or defendants as representative of other numerous persons. But then the second requirement is that when a representative suit is filed either by the plaintiffs or against the defendants, then in every case, in all such cases, notice regarding filing of such suit, if practicable, be sought on such numerous persons. So normally it is not practicable. Suppose someone notice regarding filing of such suit, can it be possible to serve the notice of regarding filing of such suit to all the villagers personally? So it is not possible. Suppose if practicable, it is to be done. If it is not possible, then such a notice is to be served to those numerous persons by public advertisement. What is public advertisement? That is by giving an advertisement using a newspaper. You might have come across such notices in newspapers under Order 1, Rule 8 of the CPC. That such and such persons have filed the suit on behalf of such and such villagers or against such and such villagers. Then any person who has anything to say or who wants to join as plaintiff or as a defendant, he may join. Such a notice comes. So this law requires that when such a suit is filed on behalf of numerous persons by some persons, or when a suit is filed against numerous persons, or against 2 or more persons representative as a representative suit, then in all such cases, notice must be given to all such numerous persons if practicable. If it is not possible, then by public advertisement, that notice will be given by public advertisement is a newspaper. Any person on whose behalf or for whose benefit a suit is instituted or defended under sub-rule 1 may apply to the court to be made as a party to such suit. When a public advertisement is given regarding filing of suit, any person having interest, either any person of that village or having interest or he may apply to the court that he may join as plaintiff or defendant. Then third is that no part of the claim in any such suit shall be abandoned. Abandon means what? Leaving it. Just suppose in the middle of the suit, no part of the claim, if a suit has been filed by some plaintiffs represented as a representative suit on behalf of numerous persons, no part of such claim can be abandoned under sub-rule 1, and no such suit shall be withdrawn under sub-rule 3 of Order 23. Order 23 provides, of the CPC provides regarding abandonment or this withdrawal of this suit. So no part of the claim can be abandoned or this withdrawal of the suit will be made, and no agreement, compromise or satisfaction shall be recorded in any suit under Rule 3 of that order. Under Rule 3 of that order means under Order 23 there is a provision that parties may enter a compromise or parties may agree for a compromise. No agreement, compromise or satisfaction shall be recorded in as per the provisions of Order 23, Rule 3, unless the court has given at the plaintiff's expense notice to all persons so interested in the manner specified in sub-rule 2. In the manner specified in sub-rule 2 means by public advertisement. as in the similar procedure in which notice regarding filing of suit is given at the plaintiff's expense. That expense will be borne by the plaintiff regarding that notice. Similarly, when a petition is filed or for abandoning a part of the claim, or for when parties want that should be a compromise, that they record a satisfaction or any agreement to that effect. So in such case, that cannot be made without giving similar notice by public advertisement. What? To whom? To all such numerous persons. Why such a notice is to given at the plaintiff's expense? Because in every suit, summons are to be served at the expense of the plaintiff. So keeping this thing in mind, legislators have made that such public notice must be given regarding withdrawal of the suit, abandonment of any part of the claim, or regarding any agreement, or regarding recording any satisfaction. Satisfaction means what is a claim is made that the other side agrees, so that the claim is satisfied, regarding satisfaction, etc. Without giving such notice in public advertisement to the general public, that means to those numerous persons. Where any person suing or defending any suit does not proceed with due diligence. Suppose a person, as you are aware, as per the previous provision, all those numerous persons are not required to be made as plaintiffs, or all those numerous persons are not required to be made as defendants. Some of them will be implicated as plaintiff or defendants. Suppose those persons do not act in due diligence. They are neglecting their duty, either prosecuting the suit or defending the suit. In such case, what will happen? So that's why there is provision where any person suing or defending in such suit does not proceed with due diligence. That if a person does not proceed in their suit with proper due diligence, means as a reasonable man, that not taking proper care, is not proper care either in prosecuting the suit or in defending the suit, then the court may substitute in his place any other person having the same interest in the suit. So any other person among those numerous persons may substitute that person who is not acting with due diligence, either as prosecuting the suit and also defending the suit. Now, so a decree passed in a suit under the rule, so when a decree is passed, if all these requirements are complied, when a decree is passed, that binds all those numerous persons. All those numerous persons. Suppose in a representative suit, a decree is passed that declaring that a particular land which has been recorded as in the settlement record as public road, that is not actually public road. So one of the villager has filed and he won the case. So in such case, whatever decree is passed, that is binding on all such numerous persons. What it says? A decree passed in a suit under this rule shall be binding on all persons on whose behalf or for whose benefit the suit is instituted or defended, as the case may be. On those persons on whose behalf a suit has been filed as representative suit, or on against whom a suit has been filed as representative, all such persons are bound by the decree. So explanation for the purpose of determining whether the person who sue or are sued or defend have the same interest in one suit, it is not necessary to establish that such person have the same cause of action as the persons on whose behalf or for whose benefit they sue or are sued or defend the suit, as the case may be. It is not necessary that the person who has filed the suit as representative suit, it is not necessary he must have same cause of action as like other persons who have an interest in this suit. Now this provision, this Order 1 Rule 8A has been included in the Civil Procedure Code by your amendment. Sometimes without understanding the proper provisions in Order 1 Rule 8A, it is misinterpreted. It is what it says, what Order 1 Rule 8A says? When a suit is filed, what? Regarding a public right, where trying a suit, the court may, if satisfied that the person or body person is interested in any question of law which is directly and substantial in issue in the suit, and that is necessary to the public interest. Only when a suit is pending, while trying a suit, what? It appears to the court is satisfied. What? That a person or body of persons is interested in any question of law. Only on question of law. If a law is to be decided, is to be settled in that case, that will affect the public interest. Then in such case, then the court may allow any other person or body of person to present his or his opinion on that question of law. Only on that question of law, permit that person or body of persons to present such opinion and to take such part in the proceedings of the suit as the court may specify. Order 1 Rule 8A is a peculiar provision. What it says? Suppose a suit is pending in a civil court, and in that suit involves a question of law, and if that decided in a particular manner, then that will affect the public interest. In such case, any member of the public or any group of members of the public may be permitted by the court only to present their views on the law, on the point of law, not on facts, on point of law to be adjudicated in that suit. So that is, suppose there is a suit where the provision of a OLR Act, a particular provision of a OLR Act is in challenge, or particular law is in dispute. If that law is decided in a particular manner, that will affect the public interest. So in such case, any member of the public or some persons or some body of persons of the public, so in such case they may be permitted by the court only for the limited purpose of presenting their opinion, for the purpose of presenting their opinion on the point of law which is involved in that case. Why? Because if that law is applied or adjudicated, then that will affect the interest of the public. Now you go through the provisions of Order 1 Rule 8A. It has been included in the Civil Procedure Code in the year 1976 by way of amendment. What it says? Power of courts to permit a person or body of persons, either a particular person or more than one person, a group of persons, to present opinion or to take part in the proceeding. To present their opinion or to take part in the proceeding. While trying a suit, that means a suit is on trial, court is hearing a suit, trying a suit. The court may, if satisfied, a discretion is there, court shall is not used. Court may, if satisfied that a person or body of persons is interested in question of law, only a particular person or a group of persons or a body of persons are interested on a particular point of law which is directly and substantial in issue in such suit. That law is directly and substantial in issue in that suit. So if that law is not in issue, they will not be, this provision will not be applicable. But present their opinion on any law which is directly and substantial in issue, and that is necessary in the public interest to allow that person or body of person to present his or her opinion. The court is also satisfied that it is necessary in the interest of the public, such person or body of persons to present their opinion on on the point of law only. Permit that person or body of persons to present such opinion and to take such part in the proceeding of the suit as the court may specify. So sometimes what happens, a person claims that he has acquired title by way of adverse possession on a piece of, on a public road, on a portion of the public land. So in such case, he has filed a suit against the government. In certain case, in such case, some villagers, they come and file petition. Though they are not parties, they be to implement them as parties as per the provisions of Order 1, Rule 80. No, that petition will not be allowed. Only when court is satisfied that the suit involves a question of law which will affect the public interest. Only a question of law substantial in issue in that suit, and that if it is necessary in the public interest, so public interest, the party, any third party may be implicated as plaintiff, as defendant, not as plaintiff, as defendant, to only for the limited purpose of presenting his opinion on the point of law which is in issue in that particular suit. So, and will take part in the proceedings of the suit as the court may specify. This Order 1, Rule 80A is applicable when first a suit is pending, and during trial of that suit, it appears to the court that there is an issue of law, and if that issue of law is adjudicated, that will affect public interest. In such case, the court may permit any third party or any group of persons only to present their opinion on that point of law and to take part in the hearing. This is the provisions of Order 1, Rule 80. Now, misgender and non-gender. Order 1, Rule 9 provides what it says: no suit shall be defeated by reason of the misgender or non-gender of parties. You must be careful. Not necessary party, only parties. Misgender. Suppose some persons would have been made as implicated as defendants, but they were not properly joined. So there is non-gender or misgender, non-gender and misgender. Misgender means wrongly a person was joined as either as a plaintiff or a defendant. Non-gender means a person was not joined either as a party as either as a defendant or as a plaintiff. So for that reason, the suit will not be defeated. This Order 1, Rule 9 provides no suit shall be defeated by reason of the misgender or non-gender of parties, and the court may in every suit deal with the matters in controversy so far as regard the rights and interests of the parties actually before it. As because there is wrong joinder of parties or non-joinder of party, the suit will not be defeated, but the court is required as per the provisions of Order 1, Rule 9 to adjudicate the rights and interests of the parties actually before it, provided that nothing in this rule shall apply to non-gender of necessary party. So you should know who is a necessary party, but a suit will be defeated due to non-gender of a necessary party. Who is a necessary party? A person is a necessary party if in his absence no effective decree can be passed. That means, suppose for an example, there are 5 brothers. One brother filed a suit for partition of the joint family property, impleading against 3 brothers, making them as defendants. He did not include the other brother, the 4th brother, as defendant. So in such suit, that 4th brother is a necessary party, because in his absence no effective decree can be passed. Even if a decree is passed, that cannot be executed. So he is a necessary party. So that's why Order 1, Rule 9 provides that a suit is to be defeated when a person is a necessary party and he is not joined in the suit. So you should also know who is a proper party. Sometimes a question comes, who is a proper party and who is a necessary party. Necessary party is a party in whose absence no effective decree can be passed, or even if a decree is passed, that cannot be executed. Proper party means a party whose presence is necessary for proper adjudication of the matter in dispute. He is not a necessary party. Even if a decree is passed without implementing proper party, that is valid. For an example, I purchased a piece of land from Mr. X. After my purchase, I am in peaceful possession of that land. My neighbor that created disturbance in my possession of that land. I filed a suit against my neighbor for declaration of right title and confirmation of my possession. So my seller is not a party. I did not make my seller as a party in that suit. If I make my seller as a party in that suit, that person will be treated as a proper party. To his presence is required to prove that he has sold that piece of land to me. Even if I have not made my seller as a party, my suit will not be defeated. So proper party and necessary party you should understand. Proper party means a party whose presence is required for proper adjudication of the matter in dispute. Necessary party is a party, if he is not implicated in the suit, then the suit is to be dismissed or suit is to be defeated. Because a person is a necessary party whose presence is required, that means for the passing of a decree, or in his absence there cannot be effective decree, or even if a decree is passed, that cannot be executed. So you are aware, the Order 1 Rule 9 provides a suit will not be defeated due to non-joinder. Non-joinder means not impleading somebody, non-joining something, non-joinder or misjoinder or wrongly joining a party. Not, it doesn't, but if a necessary party is not joined, is for non-joinder of necessary party, whose suit is to be defeated. Then suits in name of wrong plaintiffs. This Order 1 Rule 10, where a suit has been instituted in the name of the wrong persons as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, when it appears where a suit has been instituted in the names of wrong plaintiffs, or when it is doubtful whether the suit has been instituted in the name of the correct right plaintiff, the court may at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake, court is satisfied there is a bona fide, there is no intention. Intention is not there. Evil intention is ultimate. That means which now so bad motive. Such a person has been made as plaintiff, or there is a bona fide mistake. Bona fide mistake, court finds that due to bona fide mistake of the party, there is a wrong impleading of parties as plaintiff, or in such case, then court is of opinion that it is necessary for the determination of the real matter in dispute as to do order any other person to be substituted or added as plaintiff upon such terms as the court thinks fit. Though in such case, when a suit has been issued in the name of the wrong persons as plaintiff, some persons were wrongly made as plaintiffs, or it is doubtful that whether it has been issued in the name of the right plaintiff or not, and if the court finds that there is a bona fide mistake regarding such wrong impleading somebody as wrongly as plaintiff, then the court may direct and it is necessary to determine the real matter in dispute. If some person be laid as plaintiff, may order any other person to be substituted or added as plaintiff upon such terms as the court thinks fit. Court finds that a person was, due to bona fide mistake of the plaintiff, somebody has been excluded as plaintiff, or so in such case the court may pass order directing any other person to be impleaded as plaintiff. Now this Order 1 Rule 10 gives the very wide power to the court to add any person as parties. What it says? The court may at any stage of the proceeding, even soon after decision, even prior to passing of judgment, either upon or without application, when application is filed or not, or so moto, and on such term as may appear to the court, or on the such term as may appear to the court to be just, order that the name of any party improperly joined, a person who has been improperly joined as plaintiff or defendant, be struck out. This power is given to the court. Court may at any stage of the proceeding, if the court finds that a person has been improperly made as plaintiff or defendant, his name is struck out, and that the name at any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely adjudicate upon the dispute, settle all the question involved in the suit, be added. So this provision is a very wide power to the court. That means at any stage of the proceeding, if it appears to the court that a person has been wrongly impleaded as plaintiff or wrongly impleaded as defendant, or any other person who ought to have been made as plaintiff or defendant has not been made, so the court may direct that if a person has been omitted to be impleaded as plaintiff or defendant, the court may direct such persons may be impleaded as plaintiff or defendant. Or the court finds that a person has been wrongly impleaded as plaintiff or defendant, the court may order that the name of such person be struck out. No person shall be added as a plaintiff suing without a next friend or as the next friend of a plaintiff under the disability without his consent. But a provision is there, suppose a minor person is to be impleaded as this plaintiff. So in such case, or suppose a minor, in such case, he should be impleaded as through a next friend with the consent of that next friend. So this is, the court may strike out and add parties. Order 1, Rule 10. So here, where defendant added plain to be amended. This Order 1, Rule 10, Clause 4 provides, suppose when a new defendant is added, so in such case the plain shall, unless the court authorize direct, be amended in such manner as may be necessary. When a new defendant is added, the court may also permit for amendment of the plain, and amend copies of the summons and of the plaint shall be served on the new defendant. So amended copies of this plaint, etc., that should be served on the newly added defendant, because he had not received the copies of the plaint earlier to file his written statement, if the court thinks fit on the original defendant. Subject to the provisions of Indian Limitation Act, Section 22, the proceeding as against any person added as defendant shall be deemed to have begun only on the service of the summons. On the very moment a person is impleaded as defendant, on that day when a summons is raised, for the purpose of limitation, that is to be computed of taking the date of service of the summons on the defendant. Then Order 1, Rule 10A, power of court request any pleader to address it. This is a provision like a amicus curiae in High Court, that when a court finds that a case involves a point of law and the opinion of an experienced advocate is required, or the submission of the deliberation of an experienced advocate on that point of law is required, the court may permit, that court may request that advocate to submit his opinion on that law. What it says? The court may, in its discretion, request any pleader to address it as to any interest which is likely to be affected by his decision on any matter in issue in any suit or proceeding, if the party having the interest which is likely to be so affected is not represented by any pleader. So what it says, if a party is not represented by a pleader, like amicus curiae in High Court, such a provision is there, court may request any advocate to represent a party in the court on behalf of that party. Conduct of suit, the court may give the conduct of a suit to such person as it deems proper. This order 1 rule 12 says, appearance of one of several plaintiffs or defendant for others. Suppose there are four defendants. One of the defendant may appear for himself or on behalf of other defendants. That provision is there. Where there are more plaintiffs than one, any one or more of them may be authorized by any other of the to appear. The other plaintiffs, suppose 4 plaintiffs are there. It is not necessary that all 4 plaintiffs will appear in each date. The other plaintiffs may authorize one of the plaintiffs to appear in the suit on their behalf, or to plead or act for such other in the proceeding. And in like manner, where there are more defendants, in like manner where there are more than one defendants, one or any more of them may be authorized by other defendants to appear, plead or act for such other in any of the proceeding. The authority shall be in writing. When such authorization is given by the co-plaintiffs to one of the plaintiffs to appear on their behalf, that authorization must be in writing. Similarly, when an authorization has been given by the co-defendants to one of the defendants to appear on their behalf and to plead on their behalf, then such authorization must be in writing. Then this next order 1 rule 13 says, objection as to non-gender or misgender. All objections on the ground of non-gender or misgender of parties shall be taken at the earliest possible opportunity. That means when the defendant usually take the objections regarding non-gender or misgender of parties. So all objections regarding non-gender or misgender of parties shall be taken at the earliest opportunity, as early as possible. In all cases where issues are settled, in cases where issues are settled at or before such issue, on the date of the settlement of issue, at the time of settlement of issue, or before such settlement of issue, unless the grounds of objection has subsequently arisen. Suppose the objection has arisen subsequently, then this provision will not be applicable. And any such objection not so taken shall be deemed to have been waived. That if the defendant doesn't take the objection of non-gender of misgender party at earliest opportunity, that is in all cases at the time of settlement of the issues or before settlement of the issues. If he has not taken, then it is deemed that he has waived that objection.